Good afternoon. Welcome to Your Compliance Queries. You may now be familiar with how these sessions work, but let me talk you through some logistics first. This session has to be an interactive session because it's about answering your compliance queries. And the way you do that is you'll see there's a link below this video. You can click on the link and submit a question to us, and we'll try and get through as many as possible. It's nice if you put your name on there, but you don't have to put your name. You can submit anonymously. Now, before we did this session, we sent out a form allowing people to vote on what topics they would most like us to cover in this session. And we came up with, there were three that were the most popular. And they were, firstly, confidentiality, navigating the grey areas. Secondly, mistakes and errors, do's and don'ts. And thirdly, terminating retainers. So we're going to cover off those three topics in that order. So if you've got questions about those three topics, do put them in the link below, and we'll try and get through as many of those questions as possible. I'm joined here today to answer those questions by four of my SRA colleagues, all of which are lawyers. I think we've got one barrister and three solicitors with lots of experience, both in private practice and in-house. And they now all work at the SRA. So we've got Justine Allen, our ethics team manager. We've got Nimi Bruce, our Deputy Executive Director of Investigations and Enforcement. Keisha Puchahiva, who's our Deputy General Counsel. And finally, Jenny Sharma, who's our Ethic Advisor. So we're going to take each topic at a time. We've had some questions in advance, so I will run through some initial questions, and then we'll get on to the live questions you're putting in. This session will be way more interesting if you ask questions. So again, encourage you to click on the link below. Now, the first topic we're going to cover is confidentiality and navigating grey areas. And I wanted to come to you first on this, Jenny. This is a subject you often get asked about on the ethics helpline. What are the type of queries you get?
Yeah, so it is a popular question that we do get on the ethics helpline. So the duty to keep your client's affairs confidential is fundamental to the solicitors and clients relationship. It is a duty that's in common law and under our codes of conduct, which is 6.3 of the codes of conduct. And it applies to all information that comes to you during the course of the retainer and in connection with it. And it continues indefinitely. So even after the death of your client, you've still got a duty to maintain that confidentiality. However, there are situations where firms may have a legal duty or an ethical challenge which requires them to share confidential information without their client's consent.
So perhaps could you give us an example of one of those instances where you may be legally required to breach confidentiality? And what about if you're less familiar with the precedent being called upon? What should your approach be there?
Okay, so the first point to remember is that the codes of conduct themselves permit you to be able to disclose confidential information if it's required by law. So one of the most obvious examples of this is if you were given a court order, for example, to disclose confidential information. You'd need to adhere to that, or if you've been presented with a warrant by the police to seize confidential information. Another example in law is the Proceeds of Crime Act 2002. So if you as a firm have a suspicion that your firm's being used to launder money, then in certain circumstances you may be obliged to have to make a report to the National Crime Agency by submitting a suspicious activity report. So most firms are aware of their duties under the National Crime Agency, under POCA. However, there are various other lesser-known statutes which empower government bodies to require disclosure in certain circumstances. So what do you do if you get a request to provide confidential information? Well, the first thing is to understand the statute or power that's being referred to, and then to do your legal research. So consider whether that statute or power does override your obligation to keep your client's information confidential. And finally, if you think it does, then go no further than what the law requires you to do. So don't volunteer any additional information.
Thanks, Jenny. And obviously, you've talked through where there may be a legal requirement, but we've got a question here about sometimes you might be in a situation where you feel that there might be an ethical requirement to breach client confidentiality. Are there other circumstances beyond, the legal requirement where you may need to do that or be justified in doing that?
So yeah, there are exceptional situations where you as a solicitor may feel that you want to disclose confidential information even though the codes don't permit it. So an example of this that we've had on the helpline is where your client may disclose to you that they've been subject to physical or sexual ongoing abuse, and they don't want you to disclose this to anyone. So you'll need to weigh up whether the threat of harm to your client is sufficiently serious enough to justify you breaching client confidentiality. We recognise in practice that this is actually very difficult for solicitors to do, particularly as there is no professional obligation to intervene in those circumstances. But we do support solicitors erring on the side of disclosure if they feel that they are faced with a genuine safeguarding concern. So if you are in a situation, an exceptional situation, such as what I've described, there is a general approach that you can consider to these types of situations. Firstly, to consider whether it's appropriate to obtain your client's consent. Now, that may not be appropriate in every situation, but of course, if you are able to discuss the matter with your client and obtain their consent, then it means that you're not breaching client confidentiality. If you're not able to do that, then consider who's the appropriate person that you would be making this disclosure to, and the practical consequences of you doing so. So, for example, you may want to let the police know, social services, a friend, GP, or even another solicitor. But consider what the practical circumstances situation will be if you do disclose, and will that achieve what you want it to achieve? Once you've considered making a disclosure, keep a very careful note of the reasons why you've decided to do that for your own record, and why you've chosen to breach client confidentiality. Only disclose what is absolutely necessary. Again, don't volunteer any extra information. And after you've disclosed, you may need to consider whether it's appropriate for you to let your client know that you've made that disclosure. Now, again, that may not be appropriate in every situation. But if you decide that it's not appropriate to let your client know that you've made that disclosure, you'll need to consider whether you can continue to act for your client. It may not be in their best interest for you to continue with the retainer, knowing that you've made this disclosure and your client's not aware of it. Finally, it goes without saying that you do none of this without having a conversation with your culp. And if indeed you are the culp and you're going through this process and you're not sure what to do, then you can, of course, call our professional ethics helpline. You'll get to speak to an advisor like myself, and we'll be able to guide you through what you need to consider.
Thank you, Jenny. And I think that's true of any of the scenarios we pick up today, that, yeah, please do phone our ethics helpline if you are unsure or you're in a grey area, you want some reassurance around what the approach should be. But perhaps, Keisha, I could turn to you on our next question, and it's more of a commercial scenario, actually. One area we know that confidentiality issues can emerge is when there is a merger or acquisition perhaps on the cards. How should you approach that from a sort of confidentiality point of view?
Well, thanks, Ben. So I want to pick up on the point that Jenny made, which is about the fundamental nature of the duty of confidentiality. And that has to be at the forefront of your mind, both as the buyer and a seller in relation to negotiations. But what you will need to do, obviously, is think about, as a seller, what information is the buyer asking for and how can you share that without breaching your client's confidentiality. So, for example, financial information, you can consider how you can share that information with the buyer potentially in a aggregated way, so you are not giving specific information about a client. We are often asked about whether individuals can share the identity of their client with the buyer. If the identity of your client is already in the public domain, then unlikely to be an issue for you. But if that information is not in the public domain, then you will need to first consider whether it's in your client's best interest to share that information, and then seek your client's consent. And we are talking about informed consent here for your client. So they need to understand what information you want to share, why you want to share that information, and need to be able to understand the questions that you're asking of them. So it's really important, and as noted in our codes, that you communicate with your client in a way that they understand. So people out there will obviously have a wide range of clients, and you'll have some really sort of sophisticated corporate commercial clients that it may be easier for you to share that kind of information with them and they absolutely get what you're talking about. Or if you have clients who are potentially more vulnerable, or whether there's potential for capacity issues, etc., you need to think about that in terms of sharing information. I think that sort of another issue that we're often that we often have to reiterate is, and it sort of goes back to the main point, which is your interests, your own commercial interests must not take precedence over your client.
Thank you, Keisha, and thank you for those who are already sending in questions. We've got a few I'm going to run through here. We've also got a few that are linked to conflicts, although there's obviously links with confidentiality there, so we will come on to them. But this question, I think quite a common scenario we've heard is that the police can sometimes get in touch with the law firm and perhaps on a sort of speculative basis to say that a former client has been arrested and is asking us to send over a file. They normally don't come to us with a court order, maybe not at first, but if the police have been quite insistent around sort of getting a copy of that file, should we be sharing that file with the police? Either Jenny or Justine want to come in on that one?
I'm happy to answer this. So so the short answer is no. You wouldn't share any confidential information with the police, unless, of course, they've got a court order. So you'd need to, pleasantly as you can, explain to the police that it's not the fact that you don't want to cooperate and you're not being difficult, but you have a duty both in law, common law, and under our codes of conduct to keep your client's information confidential. And if they make any reference to them having the right to, through any statute or any power, then again, ask for them to specify what the power is or the statute is, and for you to again, as I previously said, just to check whether that power or statute exists and whether it does give you the power to override client confidentiality. But just to take your time in respect of that, and then if you're not sure, obviously you might need to take some legal advice in respect of what they're referring you to.
Thanks, Jenny. We've got another scenario here, which is my client's adult child has contacted me asking for a copy of their mother's will, and she's named as an executor in that will. And the mother's still alive, but has recently moved into a nursing home. Am I permitted to release the will to the child, or the adult child, as it's claimed in this question? I think I'm still an adult child, but Jenny,
Yeah.
do you want to come in on that one?
Yeah, of course. So again, adult child is not the client. The mum is still the client. She's not died, so the will doesn't take into effect. So while she's alive, she's still the client. Now, if she doesn't have capacity, and the solicitor may not know this unless they go to the nursing home and check with their client whether they have capacity or not, then if she doesn't have capacity, then there may be an LPA that's out there, and daughter may be the attorney under the LPA, but that's a whole different area to consider as to whether it's registered and whether that's the case. So in the short, that even if mom's not able to come into the office, or there's some issues with her physically being able to provide instructions, solicitor needs to continue to adhere to client confidentiality there.
Thank you, Jenny. Perhaps Keisha, I could come back to you, because it's back to this issue of mergers and acquisitions. Obviously, sometimes mergers and acquisitions are on the cards, but then they don't actually go through. What do you need to do then?
Yes, so you need to give this some advanced thought and have an express agreement between both parties about what will happen in terms of returning information or destroying information, because you obviously want, once that deal has broken down, you don't want the buyer to have access to that information anymore. So yeah, so just think about it in advance is really the advice that I'd give.
Thank you, Keisha. Now we've got, as I say, we've got a few questions around conflicts. I'll weave some of these ones in. Question from Simon, and Simon's asking what guidance is available when acting for a borrower and a bank in a commercial lending scenario. And he mentions that in Scotland, he think that there's a rule of £250,000 is you shouldn't act where the loan exceeds that. Justine, perhaps I'll come to you on that one. Is there a limit here or something in our rules about that?
Okay, thank you, Ben. Yes, there's no limit that's set out in our codes of conduct. So basically, you've got two clients here who you owe separate duties to act in the best interests of, if you're able to act for both of them in advising them, and possibly not if it's anything but a standard loan on commercially agreed situation where there isn't any negotiation. So it's not the same as Scotland, it's different. You just apply our general conflict rules in terms of whether you can advise both parties.
Thanks, Justine. And perhaps I'll come to you on this one as well. We've had a question from Jeremy, and it's about, well, basically the question is it okay for third parties to pay a client's bill? There might be scenarios, for instance, where it's a parent or employer where that might be necessary. And he asks, and what sort of checks or steps or statements would be required if you're doing that, and what about when it isn't payment of an invoice? So a few parts of that, but the headline question was: is it okay for third party to pay a client's bill?
Okay, so just starting with that first part of the question, basically it comes up fairly often where parents perhaps want to pay the bill for their child where they're purchasing a property, for example. It's a fairly common question that we have on the ethics helpline, and that's fine, they can do. The point is that they're not the client, and if they need any advice about what they're doing, be it paying a bill or contributing perhaps to the purchase price, that's where you alluded to conflict, but this is a classic conflict situation. You've got two parties, you can't advise them both in their best interests. The other party, i.e. the parents here, if they need advice, would need to go elsewhere to an independent solicitor to receive that. Do you want to pick up any of those additional points that
No.
Or are we okay?
So yeah, there was the bit about steps or statements or when it isn't payment of our invoice, but was there anything you wanted to add to that, Jenny or Justine, that we didn't cover?
I would just say that really at the outset it's quite important that firms speak to their clients. Let's say it's the son, for example, who's their client, and the father is paying, whether it's towards a purchase or paying towards costs, is that they do have a conversation with their client and with the third party, the father here, as to what would happen if there's any surplus funds left, because often what can happen is payments are made, there's surplus funds left, and then client is saying, well, they're due to me, and the third party is perhaps saying, well, no, that wasn't actually a gift, it was a loan, and they can end up in a dispute. So if you can try and negotiate and deal with that at the outset before funds are provided, then it's less likely to become an issue where you're left with funds on account and two parties that don't agree as to where these funds are coming back to.
Thank you for that. As I say, continue to encourage you to put in your questions. We're already getting some questions in around our second topic, which is about mistakes and errors. And then also a reminder that our last topic we'll be covering is terminating retainers. So please put the questions in about that. But we have another question here on this topic, and this is from, well, it's sort of again on the conflict angle. This is Steve, who's asked, in our complaints process, if the client is unsatisfied with the response, it's escalated to the COLP for review. However, they might not be the best person for this in certain circumstances. So can the COLP delegate this responsibility to another partner or perhaps even someone external if the COLP's not the appropriate person? What's our advice there?
Okay, shall I start off with this one, Ben? Is that okay? So obviously all firms have to have systems in place to address all sorts of scenarios that might arise, including complaints. And obviously it's foreseeable that you might well have a situation where the complaint is against the complaint's partner who would be dealing with it ordinarily. So you need to think ahead and plan for that situation arising. And this is something that we're going to echo going on to the next section about what to do when things go wrong. It's about having that foresight, looking at the risks. I need to plan for when that happens, not if that happens, because it's probably going to. And therefore deciding what is an appropriate course of action in a particular scenario. You might not even be able to think of all the scenarios that arise. I know in the ethics team, we're constantly surprised by novel situations that we haven't thought of. And it's just acting appropriately in those circumstances. Jenny, did you want to come in at all?
No, I think it's obviously 2.1 of the firm code, which is that you need to have systems and controls in place. So it's a matter for you to be satisfied that you have those systems and controls in place to be able to deal with that complaint.
Thank you, Jenny. Well, you just mentioned there, Justine, sort of managing mistakes or errors or anticipating what might happen. And so that's probably a good segue to move on to our second topic, which is about the do's and don'ts when something goes wrong. So we're going to be talking through that, and particularly errors or mistakes that you may have made on a client matter. And I suppose one of the headline messages here is actually where people often get into real issues is actually not when they've made a mistake. Mistakes are inevitably going to happen within any firm or business or walk of life, but it's if you then respond in the wrong way, and in the worst scenarios, some people can get in a right mess trying to dig themselves out of that. So, Justine, what should you do when an error is made? What are the key things to do?
Okay, well, the first thing I would say is try not to panic or bury your head in the sand. You're going to have to take action to deal with the situation, possibly to rectify it, but you're going to have to take some positive steps. And this is where the firm should really have a system in place that all the employees in the firm are aware of in terms of what they personally should do when they discover a mistake. It may not even be their own mistake. And it's a case of notifying the correct person who's going to be able to help them and to assist them to take the right action in that situation. The code of conduct does help us and gives a simple direction in relation to what you should do, which is being open and honest with clients and making sure they're aware of what's happened and explaining the likely impact on them, and putting matters right if that's possible. It's not always possible or appropriate. So it's that initial stage of tell the right person and talk through with them and come to an agreement about what is the next step, what's the right course of action in relation to the particular facts that you've discovered. So if it's a very trivial mistake, for example, can be quickly remedied, you probably should take action quickly in your client's best interests, then you should do so. But you've got to tell the client afterwards, even though you've put things right. There's no covering it up or hiding things. It's a case of being open and honest in order to comply with your obligations under the codes of conduct. If it's more serious, then you might take different steps.
Yeah, and do you want to talk us through what those steps might be if it is more serious, Justine?
Yeah, okay, thank you. So that's where you're thinking, well, do we need to tell our insurers about what's happened? We might need to get their consent to make any admissions of liability or to take any steps in relation to putting matters right, for example. And this is where it's crucial to have liaised with the correct person within the firm to consider that issue of disclosure and what to do next. Again, it's explaining what's happened to the client, but here in this situation where it's anything but a very minor issue, you're going to be probably saying to them that they need to take independent advice on what's happened, because the best course of action might not be for you to put matters right. It might be for them to actually sue you. They need to weigh up what's in their best interests, and you would have a situation where you're in an own interest conflict if you attempted to advise them in relation to the situation, because of course you're going to have your own self-interest or the firm's interests in perhaps taking a certain course of action.
Thanks, Justine. And you've sort of touched upon there that there may be scenarios where it is appropriate to remedy a situation, but then there might be scenarios where it isn't appropriate to remedy it yourself. Like, how can you judge that? What should you be taking into account?
It's very much on the particular facts. It's impossible to say in this situation it's fine and in that situation it's not. And this is where it's crucial to have that conversation with someone of sufficient experience, seniority within the firm to decide on what is the right course of action. So it's in weighing up the merits of doing one thing or doing another. It is difficult, and it would need to be done on a case-by-case basis. And that's where, as we've said before, talk to the ethics helpline. We can help you consider what the sorts of things that you need to think about to come to the correct solution.
Thank you, Justine. And perhaps, Nimi, I could come to you with this next question. You've mentioned just in the answers there that if a mistake is more serious or has a material impact on the client, you should advise them to seek independent legal advice. If the client is long-standing, or is the firm familiar with them, and you have acted to remedy the situation, Nimi, why is that a requirement?
So because it's actually quite straightforwardly a potential conflict of interest, and there is likely to be a conflict of interest because, of course, at that point you've got a solicitor who quite understandably is considering their own liability, whether they've been negligent, what steps they need to take to protect their own position in that sense. And again, not a criticism, that's something everybody would do in that situation. But unfortunately, that is just simply incompatible with dealing with a client who's interested in seeking redress in relation to their matter. So where an own interest conflict does arise, and that would be a situation where an own interest conflict has arisen, you would need to advise your client to seek independent legal advice. That's quite straightforward. And that would allow them to be able to make an informed decision, both about what they want to do with their case, but also if they wanted to pursue a claim of negligence against you or not.
Thank you. And this leads into a question that Abigail has asked, and it's on that theme. She's asked, in circumstances where you've made an error, obviously it's natural to continue to want to act and to rectify the error, the mistake. But assuming you are satisfied it does not give rise to an own interest conflict, do you still need to in every case to insist the client seeks independent legal advice about your proposed course of action before you could proceed?
It's certainly very good practice to do so, and would be the risk-averse way of practicing.
Thank you for that. And perhaps I'll come back to you again, Nimi, then on, I suppose, regardless of the scale or outcome, one thing we always advise is that, keeping records of your decisions is important. So what records would you expect a firm to keep in these types of matters?
Yeah, and again, I think firms can get very worried about documenting things and how much to put, and what needs to be the content. And it really doesn't have to be sort of reams and reams, War and Peace in Latin. It's about keeping a common sense, simple note, providing evidence of the decision-making process, what steps were undertaken, how the reasoning was formulated, risks, and especially around the risk of the conflict. It's really good practice to document this, not only because it will help in identifying what's got wrong, but also in terms of reflecting on lessons that might be learned from the incident, because we all need to be reflective practitioners, and solicitors are human beings like everybody else. Things do go wrong. It's important to look at why they've gone wrong so we can take remedial and rehabilitative steps to make sure it doesn't happen again. And effective risk management procedures should be in place, because that fosters a culture where staff feel safe to openly acknowledge and discuss mistakes. We talk a lot in regulatory about duty of candour. And by doing this, firms can promote shared learning and continuous improvement across the organisation.
Thank you, Nimi. We've got, I suppose, another spin on this topic, which is, can a solicitor take limited urgent steps even if they decide they need to cease acting because of a conflict? So is there a sort of halfway house in terms of what they can do? Do you want to come in on that one, Justine? Or?
Yep, I'm happy to, yes. So this is a situation where they would have to consider, if they take that step, are they able to do so in the client's interests. It may be that something is required urgently. They do that, but after they've taken the step, they tell the client to take independent advice, and somebody independent can advise them about the consequences of and the outcome on them and their case, because it's all a situation then of looking forwards. So it might be necessary to have taken the step at that stage for very good reasons, but it doesn't negate the requirement for the client to still consider taking their own independent advice on what's happened.
Thank you on that one. We've got a few questions come in on sort of source of funds AML themed questions. Now, although we could deal with that here, we actually have another session at the virtual conference that's entirely around that theme. So I'm going to suggest actually for those questions, you'll be best placed at asking them. I think it's in tomorrow, the session. But we do have another question here, which actually jumps back to the theme of confidentiality. It's somebody's asked, if a client lets slip in a meeting that they are improperly declaring funds for tax purposes, is that confidential or must it be reported? Jenny, did you want to come in on that?
Yeah, okay. So some of it depends as to what the retainer is that you're dealing with for your client. So if it's a case that the information that the client has informed you about makes an impact on the matter that you're dealing with, then it may be the case that you'd need to speak to your client about declaring what they've done to, whether it's HMRC or whomever they need to do so to put it right before you're able to continue with the retainer, because failing to do so may then mean that you're complicit in the acts of your client in misleading others. So 1.4 of the Code of Conduct requires you not to do that. So you might need to speak to your client about saying, well, now I've heard what you've told me, I'll need you to put it right before we can move forward, because I'm not able to put forward the figures that you've provided, for example, because I know that they're not true. If, however, your client refuses to do so and says, no, actually, you can forget what I've told you, then you'll need to consider entering the retainer because of course, if you're moving forward, you may be misleading if you're using those figures, for example. But you wouldn't be able to breach client confidentiality there because you have, as we've already discussed, a duty to keep your client's affairs confidential under common law and in accordance with 6.3 of the Codes of Conduct. If the actual information that he's dropped to you has nothing to do with the retainer that you're dealing with, then you may want to just have a word with your client about obviously putting it right. He may want to go away and seek independent legal advice about what that means for him if you're not able to provide that advice, but that may not then prevent you from continuing with your retainer if it's totally unrelated.
Thank you on that one. Now, part of my job as chair is, one, I should be trying to keep the lights on in my room, and you may have noticed the lights have gone off. But secondly, it's also to keep an eye on where I should bring people in because they've got something good to say. And Keisha, you gave me a nod and a wink and I ignored you. But I think you had something you wanted to add to the question we just had a moment ago around record keeping. So accept my apologies, but Keisha, do you want to come in on that?
No, that's absolutely fine. So it was just to add to Nimi's really helpful answer, which is, and just talking from personal experience, that when documenting decisions, actually and why that's a really helpful process is because issues come up that you may not have thought about when you're thinking about the decision and discussing it with others. So when you're setting out your rationale, further questions might arise, and so it's a really helpful discipline, and as I say from personal experience, it's a really helpful discipline to make sure that you're capturing all the relevant issues that you need to in terms of professional judgment. That was it. Thanks, Ben.
Thank you, Keisha, and I will not ignore you ever again. So we got one other question, which sort of covers something we've already covered a bit, but it's probably worth re-emphasising again, of how do we know whether we can remedy the mistake ourselves as a question? Again, did one of Justine or Jenny want to come in on this one?
Yeah, I don't mind.
Yeah, go ahead,
okay.
Justine. I'm pleased
Whether
someone came in, otherwise it would have been me answering and that would have been a disaster for everyone. So go ahead.
Okay, but Jenny, feel free to chip in as well, of course. So basically, this is going to be assessing whether there's an own interest conflict in terms of what you're doing, and whether you're in a position to advise the client independently about a certain course of action. That's assuming it's not anything straightforward, and it might be helpful here to talk about sort of scenarios or situations where this could arise. So say, for example, you've got a very small technical drafting issue in a document, and you can put that right, agree with the other side. There's no, it's not sufficiently serious to alter the document at all. It's just correcting a mistake. That's straightforward. That's a situation where you would act, you deal with it, probably no cost to the client. You tell the client what's happened. I drafted your name incorrectly, for example. I've put this right, no problem at all. Where you've got something more that goes more to the heart of the matter. For example, if you've got to take the matter back to court, to ask the court to allow you to file something out of time, for example, and the court could say no, that's something where it may be, if it goes the other way, i.e. against you, that's going to have a much more serious impact on the client and on the client's case if you can't get that piece of evidence or that document admitted. So you might want then to suggest to the client that they take advice before they agree or consent to the step that you're suggesting.
Thank you, Justine. We just had another question come in, probably building on the question we had from Abigail earlier, which is, if a complaint is made and the client is happy with the resolution and wants to stay with us, can we ask them to sign a disclaimer? Does that cover us for any claims against us further down the line? Jenny, perhaps I'll come to you on that one.
Of course, yeah. We wouldn't really expect you to be getting your client to sign a disclaimer to say that they can't then make a complaint against you. Obviously, the Code of Conduct paragraph 8 permits and expects you to have a complaints procedure that clients are able to follow. So if the client has made a complaint and you've dealt with it and you're satisfied, you're happy with it, there shouldn't be any need for a disclaimer. And I don't think that the disclaimer really is going to protect you in any way if the client then later on discovers that, oh, actually, that they're, for whatever reason, not happy with what the response was that was given. They may choose to make a complaint to us or to the legal ombudsman. So I think you'd need to really carefully think about whether that's in the best interest of the client. Principle 7, for you to be getting your client to sign a disclaimer to say that they can't raise this issue with you again in that respect.
And presumably as well, Jenny, the impact of whatever the problem was might not be clear at the time to the client, or might only become, if there is losses, that might only become clearer further down the line.
Yeah, and of course it's a question of, obviously you have a retainer with your client, trust and confidence between you and your client. So getting your client to sign a disclaimer and then continuing with the matter, I think you'd need to really carefully think about whether that's what the basis of the retainer should be. If you felt that the matter hasn't been dealt with properly, or your client feels that it hasn't been dealt with properly, then that they're entitled to continue to look to you for resolution. And if you feel that there isn't any further resolution that you can provide to them, then obviously that's what the complaints procedure is there for.
Thank you. So we've got about 15-20 minutes left, so we'll move on to our last topic now. Thank you for everyone who's putting questions on that. We've also got one question about Missouri, which is, if we have time, we'll come to that at the end. But the last topic we wanted to talk about was terminating retainers. Now, that is not a topic that is expressly covered within our rules. It's an issue we do get a lot of queries about, though, and the principles you have to follow are set out in common law. So perhaps, Jenny, we could kick off with you. What are the sort of situations that could arise that may lead a firm to terminate a contract?
So you may have a situation where the retainer automatically terminates, for example, the death of your client, or the bankruptcy of your client. Or you may have terms of engagement where there's a specific provision that if an event occurs, then the retainer will naturally come to an end. And that's contractual terms between yourself and your client. But if it's not any of those scenarios, then in common law, a solicitor should not be looking to terminate the retainer unless they have a good enough reason and they can give their client reasonable notice. Examples of what would be a good enough reason: you may have an own interest conflict between you and your client. You may have two clients that have a conflict of interest between them. You may have a situation where your client wants you to mislead the court, or they want to mislead the court, or they want you to put forward submissions or statements which are not properly arguable. But you might also have the situation where your client contractually isn't paying your fees or paying your disbursements, and you therefore want to bring the retainer to an end for that reason. So if you get to that type of situation, then there's a few things that you would need to think about, because it's not just about you having a good enough reason, it's also about whether you can give reasonable notice. So as a benchmark, what we would say is a benchmark, you can consider whether if another solicitor were to take over the matter, how long would it take them to come up to speed with it? So if it's a couple of days, then that actually may be reasonable notice. But if it's going to take them longer, then that may not be the case. And it's usually not reasonable to be able to end the retainer a couple of days before a hearing, so that may not be reasonable notice. However, what we do say is that it very much depends upon the individual facts of the matter and upon the reasons for termination and case law as well, because in the scenario I've just given you, not ending the retainer before a court hearing, it might be the case that you're actually at court and your client is giving evidence and they lie whilst they're on the stand. You may therefore need to step away from the hearing and the retainer at that point. So that it's recognised, obviously, in common law that that would then be reasonable notice.
And can I pick up that? Thanks, Jenny. And well, let's pick up. There's a scenario here had come in. Let's say the client has just misled the court, and I've decided to cease acting. What can I tell the judge about the reason I'm walking off halfway through a case, which is not a great scenario?
So you'd obviously need to bear in mind confidentiality to your client. You wouldn't be able to let the court know the reasons why you're not able to continue to act, i.e. your client has misled the court, unless your client wants you to, but the chances are they probably won't. So what we would say is that you can let the court know that there are professional reasons or regulatory reasons why you're going to need to step away from the case. Judge may not be happy with that, and we've had calls to the helpline where solicitors have said that they're at court and the judge is not prepared to accept that as an explanation. The judge can order you to disclose the reason, and of course if you're ordered to disclose, then that's one of the reasons where you're required by law to provide that information. So you might then be in the situation where you can explain the reason why, but you'd need to be very obviously careful that that order from the court does allow you and permits you to override client confidentiality. But ordinarily, I think letting the judge know that there's a professional reason why you're having to step away should be enough of a hint to the judge that it's something to do with client confidentiality.
Thank you. Keisha, perhaps I could come to you on this question we've had come in, and this person's asked, they've said that we've talked a lot about recording decisions to show thinking if challenged further down the line. And as we know, there isn't a rule for every single scenario. So often you're having to weigh up sort of principles. So this person asked, what should we be putting down to demonstrate we've given the sort of issue the due diligence it deserves? What's your advice there?
Yeah, so it will of course depend on the specific facts of the issue before you, but I think that's a really great starting place, isn't it, to say this is the problem that I'm faced with, and then these are my professional obligations, and this is how I've considered the issues. There may also be, issues coming in from case law, etc. But it's about showing that you've walked your way through in a logical manner and considered the relevant issues, and as Nimi said earlier, it's not about writing chapter and verse. It's about the key points that you've taken into account. So if further down the line, 6 months down the line, a year down the line, somebody comes to you, whether it be the SRA or whether it be your client, and they say, why did you advise me to do X or Y? You can go to your record and you can give a full and complete answer. Because we will not, with the best will in the world, we're not all going to remember every single issue. We're our profession out there are dealing with really complex issues and a lot of issues, and so you're just not going to remember it. So part of this is providing a level of protection for yourself, and recording the issues that you've thought about. So and it's about exercising your professional judgment in those circumstances. So there is no hard and fast rule that we can provide you with, but it's about noting down as complete an answer and as reasoned an answer as you can at the time.
And Nimi, could I come to you on that point? Presumably, because you see a lot on your work on the investigation and enforcement side, is it typically that in the scenarios where people are getting in deep water that they haven't haven't recorded how they've weighed up their ethical obligations? So, or is it more typical that sometimes people are writing it down, but we fundamentally disagree with it? Is it the former or the latter, or is that too simple a question?
I don't think it's too simple a question. I think it's a mixture of both. I think that it can be surprising how bad a record is when you're doing any kind of file review, and I think that the importance of creating a kind of audit trail honestly just cannot be overstated. And this kind of idea of sort of candor and openness and transparency is just so fundamental and important, because quite often it's not really the thing that goes wrong originally that can create difficulties for individuals and firms. It's actually what happens next. So just having that in mind and sort of slightly just being on just always having that kind of, for me, I always think about it as sort of a high court judge, or just it being in the bundle of a court document or in the Daily Mail, and just sort of trying to think about actually what would I have wanted to put in terms of making this understandable to anybody reading it at all. And I do appreciate that sometimes there can be a sort of a desire to sort of put your head in the sand, and then again that's just a human reaction, but it's probably not the right one. In fact, I know it's not the right one, sorry.
Thank you, Nimi. And perhaps, Justine, we've got another question come in, a good question. Are there specific rules if the reason for termination is discriminatory behaviour towards my staff? So a client is being discriminatory to staff within the firm. Is that a reason to terminate? Do we have rules around that?
We have issued guidance in relation to Principle 6. And this may well be a good reason for not continuing to act for somebody. Obviously, if somebody is doing something that is contrary to the law, and obviously as an employer, you have obligations to your staff to ensure that in their work that they are treated properly and lawfully. So it may well be a justification for terminating retainer, or indeed not taking a retainer on if a client comes to you in certain circumstances expressing certain views.
Thank you, that's helpful. We've had another question here. If a fee earner leaves and you have no additional staffing capacity to deliver a proper standard of service for that fee earner's client, is that a reasonable reason for termination?
Yeah, so I'm happy to answer this one.
Okay.
So if you can't provide a competent service, and 4.2 of the Code of Conduct for Firms requires you to provide a competent service. If you feel that you can't provide a competent service, then you shouldn't be acting. So I think you'd need to really have a conversation with the client, though. You'd need to consider what stage that their case is at, and what additional help that they may need. You might need to signpost them to another firm. You may not be able to step away if you've got a hearing, for example, next week. you may need to continue to act until that hearing has been dealt with. But it really does depend on the facts of the matter, because of course if the only fee earner that was dealing with the matter and you've got nobody else skilled to deal with that area of law and they have left, then it wouldn't be a competent service, and it wouldn't be in the best interest of the client for you to be continuing to deal with their matter. So you might need to be signposting them elsewhere, assuming you've given them enough notice.
And I suppose on a similar theme but slightly different, if a client is not paying and firm has asked the client to pay on account to cover a hearing, but they're not paying, is that a good reason to stop acting for the client?
Okay, so if a client fails to make a reasonable payment, this may constitute a good enough reason. Solicitors Act considers that. So you may want to terminate the retainer if you haven't been paid your fees, but again, you'd need to really think about when that took place. So, you know, if you've not had that conversation with your client until 2 days before the hearing, it may be unreasonable for you to expect for them to be paying your fees. So if you've given them sufficient notice and they still haven't paid your fees, then it may be reasonable for you to terminate the retainer. But of course, if you're leaving it a day or two before the hearing, you know, even a week or so before the hearing, there may not be sufficient time for them to be able to instruct another solicitor.
So I wanted to just thank you for that. So I was just looking at the questions that are coming in, as well as somebody trying to break into the meeting room I was into, but they've been scared away by seeing a webinar come in. So sorry about that. We've only got a few minutes left, but one thing I did flag was we had a question in relation to the Mazur case, which I'm sure a lot of people will have seen a lot of sort of coverage and attention on over the last few weeks. And this question, and I think perhaps this is for you, Keisha, this is someone who's asked, will the SRA provide reassurance that if someone self-reports in relation to conducting litigation, whether fallout from Mazur, and you know that they've perhaps unwittingly done something wrong, but they haven't been deliberately in breach of it, you know, can we provide reassurance about the action we might be taking?
Yeah, happy to take that, Ben. So first of all, I think what I want to highlight, and I don't want us to run out of time about, is that we have our new hot topics page, which individuals can access on our website. And there we've brought together our resources in relation to the conduct of litigation. But then dealing with that question, we will consider each case on a case-by-case basis. So if you are considering self-reporting to us, please don't assume that a self-report will automatically lead to an investigation. We will consider the facts of the case. We will consider what remedial action you might have considered taking, and it may be that actually you need a period of time in which to undertake that remedial action, which, you know, it could be possibly just simplifying this, but it could be making sure that you have sufficient authorized lawyers there to conduct litigation. But we will look at that remedial action, and then we will consider whether it's in the public interest to take forward a prosecution. So it's as with all our investigations, there are stages we go through and decisions that we make. But in the first instance, I would say, you know, consider this situation that applies to your firm, and then get in contact with us and speak to us about it.
And just to thank you for that, Keisha. And you've flagged we have the hot topics page on where we bring together all our sort of guidance, relevant guidance and thinking around Mazur. But I suppose the headline, Keisha, just for those listening, is, I mean, our position hasn't changed, although we don't think the position in law has changed, in the sense that you can't conduct litigation if you're not an authorised person or not authorised to do so. But you can certainly support the conduct of litigation through under supervision, or you can support litigation.
Can support those conducting. Yeah. So I think there's definitely been a lot written about this, as we said, our guidance has not changed. The position in law has not changed. I think it's certainly brought this brought the difference between an authorized person being able to conduct litigation and what non-authorized people can do in terms of supporting litigation. That's been brought to the attention of a number of people, but the fundamental position as set out in the Legal Services Act 2007 has not changed.
Thank you, Keisha. Right, we've just got a couple of minutes left, so I'm going to try and squeeze in a few more questions that we've had coming in. There's one question actually about in-house solicitors or in-house clients, sorry, in terminating retainer. Not 100% sure the nature of that question, so I suggest on that question you have a look at our in-house guidance, but also phone our ethics helpline after this, and you may be lucky enough to get Justine or Jenny on the call, or one of our other ethics colleagues who can help with that. But another question we've had, and it goes actually back to our previous topic, is if you advise a client to take independent legal advice, but they choose not to do so, can you continue to remedy a mistake? Justine, did you want to come in on that one?
Yeah, I'm happy to. Thanks a lot, Ben. Basically, no. If the client refuses to take that independent advice, they're not being advised in their best interests. It's going to be extremely risky for you to proceed to do anything. So you do have to insist. You could offer to pay for the independent advice. You could suggest another solicitor who would be a person that they could go to seek that. But yes, the situation is they do need to have that independent advice because you've got a conflict. You cannot advise them, and then you agree a way forward with the client. So take their instructions after they've had the benefit of being properly and independently advised about the proposed course of action.
Thank you. And has your dog joined you, Justine?
Sorry, yes.
No, well, not sorry. Love a dog. So I was wondering whether it's some clever AI filter you'd put on.
No,
It's a
it is real.
dog. And then one final question, perhaps got time for, again, back to the terminating retainers theme. Our client has stopped giving instructions. How long should we chase them before terminating the retainer? And I imagine there's not going to be a simple, it's 100 days or 50 days, because it'll all depend on the details of the case. But yeah. Jenny or Justine or somebody did want to come on this one?
Yeah, I'm happy to deal with that. So yeah, I think you're right. It really depends on the facts of the case. So do they have a hearing coming up, for example? Are you actually able to contact them? Is it the correct email address, or what's their reason for not responding back to you? Are they picking up the phone? Just giving them sufficient warning that you're going to be terminating the retainer, and you being satisfied that they're aware that you're going to terminate the retainer. So are they receiving their emails or their letters? And if they've got a hearing coming up, and whether you can give them sufficient notice of that. So I think you really need to think about the facts of that. But again, you can give us a call on the helpline and you can talk to us about the specific facts, and we're more than happy to be able to talk you through it.
Thank you. And I think that is probably a perfect note to finish on, because as I say, hopefully you found that useful, but this is the start of a conversation if you've had a query that you don't think has been answered, or you have follow-up queries, because as I say, do phone our ethics helpline, do go to our website, have a look at the guidance that's there, or pick up the phone if you want support. We're here to do that. We want to help where we can and support you to be compliant. Now, we hope you found it useful, but it's in the eye of the beholder. So there is a feedback form which you can click on below. Please let us know your views, because it helps us understand what works well and what we can do to improve this. I need to get lights that stay on for one. There are still 4 sessions to come this week. So we're sort of halfway through our virtual compliance week. And tomorrow we've got a conversation with the chair and chief executive, a source of funds and financial crime session. And as I say, those questions that people put in, please join for that and you'll be able to get good answers there. And we've also got a session on continuing competence, get it right. And then to round off the week, we've got account rules on Thursday. So finish off to say thank you ever so much for joining us. Thank you everyone who put the questions in. It was a really good session. And thank you for Justine for cheering me up with your dog. Bye.